Room with Judge Adams.
All right, Mr. Petrie, this, as I indicated again, and I said again, this is an informal, quote-unquote, pre-charge conference, and we may be able to cover some issues that there may be, quote-unquote, an agreement on the requested charge. And the way we do it, Mr. Petrie, we just normally go through and just tell me if you have any objection to their proposal, then I go through the defense proposal and ask the same thing for the state. Any objection to request number one, Mr. Petrie?
From the state, you're talking about?
That's correct.
No, sir.
In objection to their request. This is the reading the indictment, that count.
Yes, sir.
No objection.
Yes, sir. I recognize that. No, sir, there is no objection.
Okay. Number.
And I can remain seated, Your Honor. So
You can. We'll do it informally for this afternoon. Count. It says count. Your request number 3 is next on my copy, Ms.
It
Green.
was a copying error on my part, Your Honor.
So there's no page 2?
There is a request number 2, and it's just the pattern charge on the issue and the plea of not guilty.
Okay. Any objection, Mr. Petrie, to?
Yeah, we had the same problem. She showed it to me, and it does appear to be the
All
pattern
right.
charge.
We'll give the pattern language on to you, Ms. Jeffrey.
Don't want to leave that out.
Okay. Okay, that's fine. Number 3, Mr. Petrie, any objection? The presumption of innocence, pattern language.
No, sir, Your Honor. The only request I would make is that at the end of the trial, if we realize that there's a certain part of the charge that has not been
Oh, yes, it'd be-
particularly judged, but
Right.
this is a correct statement of the law.
That's
We have
correct.
no objection as long as it's tailored specifically for this evidence.
Correct. And obviously, and that's what I'm saying, this is a pre.
Yes, sir.
Here. And obviously, things will be tailored. It just said, yes, it'll be tailored. Number 4,
No objection.
we'll give number 5.
Bear with me, please, sir.
No problem. Is this, what is it? I don't see.
Your Honor, my only objection is that it doesn't have a citation of authority. I don't know if this is from the pattern charge or not.
It is a pattern charge, as is indicated by the...
Oh, I said, she puts it
Oh,
at the top.
mine's just covered up.
Yeah, it's 1.30.
Then no objection, Your
All
Honor.
right, we'll give 5 pattern. Number 6, and this one needs to be tailored for this particular case.
Exactly, Your Honor. Both 5 and 6 would.
Okay.
And Your Honor, with all due deference to the state and the defense and the new pattern charges, we might need to address state's request number 7, which is also duplicated by the defense. It seems that we've been given short versions, long versions.
Correct.
11th Circuit versions, Georgia versions, and I think it's going to need a little final tailoring, but certainly we have no objection to a pattern charge on direct and circumstantial evidence being given.
All right. We will, and obviously we're going to have to tailor it, but these are just real. Okay. I will tailor 6 and 7. Number 8, question by witnesses.
Your Honor, as a pattern charge, no objection. I think it's in brackets now, bare intelligence. I believe that may have been disapproved of. I'll check with Mrs. Carlson.
I think you're right. I think that language should be removed. Ms. Carls, any objection?
I don't, Your Honor. It still is contained in the pattern charge, just with the parentheses that's included on there, so I have no objection to taking it out.
All right. We're going to take out Ms. Jeffrey's, it wasn't in brackets, their intelligence. So we'll give 8 with that modification. Number 9.
No objection.
All right, we'll give 9 as written pattern. Number 10.
Again, no objection, Your Honor. It's
Well, it has
the
to be-
rule.
yeah.
Just make sure it's tailored.
All right, I'm going to just put a question mark by 10, but that'll be tailored. Number 11.
Your Honor, I think number 11 needs to be taken in conjunction with state's number 12. And again, the council has put both the old rule and the new rule here together. Just need some fine.
Both of them here. Ms. Green,
They are,
yes, ma'am.
they are both still pattern, Your Honor, and so I think that state's request to charge number 11 is a correct and applicable statement of the law. But the state's request number 12 is also still a pattern charge. And so because they are both pattern, I don't have an objection to giving 11 as opposed to 12. But if 12 is given, I believe 11 also needs to be given.
And at this time, Your Honor, the only thing I would point out is that whether or not a witness has been shown to have a, quote, character for untruthfulness or bias toward a party is a determination that this court will have to make at the conclusion of all.
Sure, I understand. Let me just put a hold on that one. This whole 11, we will hold, well, number 12, Mr. Petrie, any objection?
slipped over.
First paragraph or second paragraph, pattern on witness impeached by.
That is correct, Your Honor. That is a correct statement.
Are you, what about, give the first portion?
Either one of them would be fine, Your Honor, except I believe that actually, I prefer the second one
The
because
credibility of a witness may be attacked by disproving the facts to which the witness
I
testified.
believe that that is the old one, Your Honor, and that that is a correct statement of the law, and I would ask that that be given.
Ms. Cross?
The first portion,
No, he's asking for the second portion. Only the second portion. Second,
I believe both are accurate statements of the law, and we'd ask that both be given.
says to impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified, period. But it says or. So I get one, we get one or the other. What's your preference, Ms. Green? Sorry, Ms. Cross?
My preference is the second portion, Your Honor. Credibility of the witness may be attacked.
Well, in that case, that's what Mr. Petrie was asking for. Since there's an agreement, I will give Mr. Jeffries only the second portion. Number 13, any objection?
Your Honor, if the court would be gracious enough to allow me to hold off
We'll hold.
objecting to that.
Oh, no, good. That's what I'm saying.
Such a departure from the Georgia
Now, I
existing law.
understand. This is all preliminary. That's what I'm saying. So the ones we can agree on, we just, the ones we have to come back to, that's what we're going to do. Definition of crime, any objection
No,
to?
sir, not from the defense.
All right, we'll give. Number 14, number 15.
Your Honor, as long as it is, some of these count require specific intent, some do not, and as long as we make sure at the conclusion of what counts are left standing, that it is tailored to the counts as drawn, we have no objection. That is a correct statement of the law.
So Ms. Jeffers will give first and second paragraph. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but means simply the intention to commit the act that is prohibited by statute.
And my complaint, Your Honor, is that obviously is a correct statement of law as to general intent.
Correct.
Some statutes require, and some of the statutes in this indictment that are implicated require a specific intent. So I just want to make sure that we are addressing the jury that this is not a universal rule that would apply even where the state is required to allege specific intent.
I understand. So there's no objection to the first, it's not with a paragraph, but the first line and the second.
No, sir, there's no objection
So
to that.
that's agreed upon. The only issue is the third paragraph.
That it might need to be tailored
It
to
will be.
specific counts.
We're going to put a question mark by that one, Ms. Jeffries. Number 16, any objection?
No, sir.
All right, we'll give. Now, Ms. Ms. Cross.
Yes, sir.
These things you've left in here, the things that are in parentheses. Now, do you want me to make these changes now, or you?
I think the language in the parentheses needs to be given the facts and the evidence in this case.
Ms. Petrie, any
I
objection?
believe, if you're talking about number 16, Your Honor,
No, yes, sir, we're on 16, the language in parentheses.
I do believe that the parenthetical language needs to be given as
All
well.
right, we will give both. It's agreed upon. 16 will be given in its entirety. 17,
That seems to be a correct statement of the law, Your Honor.
all right, we'll give, obviously you can come back and change more, but we'll give 17 in its entirety. 18, and they have modified, well, someone deleted some language
Yes, sir.
in the
That appears
parentheses.
to be a correct statement, Your Honor.
All right, we'll give 19. This is 1.3190.
Your Honor, we have obviously no objection to this as long as those counts that this doesn't apply to are also covered.
I understand.
Yes, sir.
But we'll give 19, I understand. We'll give 19, 20.
That's what I was just talking about. And
An exception to the rule.
yes, sir.
Right.
We have no objection to the rules given in states number 20. We believe that some of the defendant's requests might be more advantageous to us, and so therefore we'd certainly like them better.
Well, I understand. But I'm saying, yeah, right.
This is a correct statement of the law, and we have no objection
give
to
20.
this rule being given to the jury.
21,
That is a statutory definition, Your Honor, no objection.
22,
No objection, Your Honor.
all right, we'll give 22, 23.
Let me read through this, please, sir.
You may.
No objection, Your Honor, as long as this charge is given in conjunction with some of the defendant's requests.
I understand. I mean, what I'm saying, I will will give, but we'll put a hold, because we'll make sure we don't miss it. We'll come back. 24?
No objection to it, Your Honor, in the context of the other request.
All right, we'll give 24 with that understanding. 25?
I believe this is a statutory definition that appears to be correct, Your Honor.
We'll give 26.
Let me just double check the
Oh, sure.
that portion.
It's been
That appears to
modified.
be correct, Your Honor, yes, sir.
We'll give 26 as modified. 27? It's been
27, Your Honor,
modified.
appears to be the same statute defining those areas that are concealment as opposed to the active false statement, and that appears to be correct as well.
All right, we'll give 28. Hold.
Hold on number 28,
Hold.
yes, sir.
29.
I object to that, Your Honor.
But the language is going to be deleted at the end.
At this time, I think that's correct, Your Honor.
Your Honor, I know that this is a correct statement of the law, but it's never seemed right to me to tell the jury they're only concerned with guilt or innocence, say that they are not to concern themselves with punishment.
Period.
Punishment only is applicable if there's a conviction. I don't know what in the world that second line adds to a jury other than allaying their fears that if the defendant ends up with a bad sentence, it ain't their fault. So I understand this is part of the normal charges that's given, Your Honor. I know that this charge has been given, but I would ask the court simply to give the first sentence. You are only concerned with the guilt or innocence of the defendant. That's all they need to know.
I understand. And I understand, Ms. Petrie. Well, let me hit Ms. Green first. Ms. Green?
Your Honor, I think that with the exception of the italicized language, at this time, the pattern charge as a whole is complete, accurate. It is been approved by the Superior Court, the Council and Superior Court judges. I think it should be given in its entirety.
Ms. Petrie, I'm going to give it over objection, but I will delete the last 3 words in that second sentence, and it will read, you are only concerned with the guilt or innocence of the defendant, period. You are not to concern yourself with punishment, period.
I understand.
Yeah, I understand. Well, exceptions of it.
Yes, sir.
All right. That is,
I'm being quiet.
I understand. That is the state's request for charge.
Actually, I have it states 30. I have another copy.
And we have no objection to that, Your Honor. It's the disjunctive, conjunctive
That's fine.
dichotomy.
Okay. Let's see. Let's see what number. Okay, page. Okay. It just wasn't in my,
I'm sorry.
I don't see the date stamp on this either. So I got, okay, it wasn't in my packet. That's no problem. No objection, we'll give 30. I heard Ms. Petrie say no objection to 30. We'll give 30 in its entirety. All right, we'll follow the same process with the defense. And you can remain seated also, Ms. Green. Any objection to, now, Mr. Petrie, although if it's the same request, although I say I will give, I'm not going to give it twice, I'm just going to give it once.
I understand, yes, sir.
I know, but I
There are quite a few duplicates here.
Right. Any objection to 1?
As a pattern charge, no, Your Honor, just the parentheses language referencing insanity isn't applicable, so we just ask that that be struck in this, in
That
the,
will be deleted, right, there's no insanity. That, what's in the parentheses on the...
It's in the fourth paragraph,
down,
yes, sir.
that'll be deleted, reference to insanity. There's no clear insanity in this case. Number 2,
no objection.
we'll give. Number 3,
I believe it's duplicative of the pattern charge, but no objection.
yeah, no, what I'm saying, yes. If it's, I'm not going to give it twice, but if it's in yours,
Yes, sir.
you see what I'm saying? So it's not going to be given twice, but I will give
Yes,
that 1.2.30. Number 4,
I think this is better governed by the pattern charge, so I would object in that it is not as, is covered by the pattern charge better, so we would object to this be given instead of the pattern charge.
And, Your Honor, if you look at defendants 4 and 5, this is one of those where they put in the old charge and the new charge together.
Mr. Petrie, obviously this is covering the direct evidence. I will give a pattern on direct evidence.
Yes.
I'm not going to give this one. I will give a pattern on direct evidence. So when I give Ms. Jeffries number 4, but I will give a pattern on direct evidence. I will give a pattern. Okay, let's see. Any objection to 5? Let me just do that one. Any objection to 5? D5?
references the code section as opposed to the pattern. We just asked that the pattern on direct evidence be given. Is this the long version, Mr. Petrie?
Mr. Petrie, is
Your Honor,
this?
this is the new code section that came into effect on January the 1st, and I believe that it's a correct statement of the law, it is applicable to the facts here, and it is a charge which will help the jury determine what the truth of the case is. So I would request that number 5 be given.
We'll give 5, Ms. Jeffries, over objection. I will give 5. And I'm going to give it in its entirety, Mr. Petrie, on what you're asking for, even though what's in parentheses.
Yes, sir.
I guess I'm going to give it.
I think that the parentheses, Your Honor, is, I'm not sure why it's there. It seems that it sort of helps explain it to the jury.
Well, I agree, but that's why I'm letting you know.
Yes, sir.
You asked if I'm going to give it in its entirety, even
Yes.
with the parentheses. That's
Yes,
what I'm
sir.
saying.
Absolutely.
Okay, that's why I want to make sure we're on the same page. Number 6, Ms. Green. Any objection?
Yes, Your Honor. No objection.
All right. We'll give 6 without objection. Number 7,
No objection.
we'll give. Number 8,
No objection.
we'll give. Number 9,
No objection.
we'll give. Number 10, we'll give pattern on expert witnesses. Number 11,
That's also expert, Your Honor, if we can just have the pattern on that.
yeah, we'll give pattern on expert, Ms. Jeffries. Number 12,
Your Honor, number 12 duplicates one of the requests from the state that I had asked the court just to hold out
all right, we'll hold.
on the specific
I know.
impeachments.
13, I understand, yeah, we're on the same page. 13,
I think when this was a state's request to charge, we agreed
It
to
is.
give only the second.
that is correct. We will give them the second paragraph on 13. 14, I believe this is in the states also.
It is, Your Honor.
This is 1.3147, we'll give as I indicated. 15,
I believe 15 and 16, Your Honor, both are in the state's request and we've addressed.
that's right, we'll give 15, 16, not duplicate, but we'll give that language. We're on the
Yes, sir.
same page.
Yes, sir.
17, we'll come back to it.
Well, yes, sir.
Yes, sir.
18,
I
we'll
do.
come back to it.
Yes, sir.
19,
I believe this is the pattern charge. No objection.
all right, we'll give 19. 20, no objection.
No objection.
21,
I do object to this, Your Honor. I don't believe this is applicable to the facts of the case.
let me hold, because we're still going. 22,
No objection.
23,
I do object to 23, Your Honor. This is inconsistent with the current state of Georgia case law.
Ms. Petrie, let me hear from you.
I think that is a correct statement, Your Honor. In the prosecution for perjury, the testimony of a single witness shall not be sufficient for conviction. I'm not saying that it takes more than one witness. I'm saying that it takes more than the testimony of one witness.
We're on 23.
I'm sorry, I'm on 23.
We're on 23.
23, what did I say?
I don't know what you're on 23.
That's what my 23 is.
My 23 is concealment of a material fact duty to
That's
disclose.
my 23.
Okay, right, they didn't, I'll look over Ms. Cross's shoulder.
Right, it's your 23.
I know, but
I understand.
they sent me the wrong copy there.
Okay.
Your Honor, this request, as the court can see, is based upon an interpretation of foreign law, and I believe that it is a correct statement of law. Is it a pattern charge? No. Is there a Georgia case directly on point so holding? No. But I believe that it would be very beneficial to the jury to hear this charge
All right.
and our client.
Thank you. Will not give. All right, number 24. You want to flip over 24?
Yes, sir. Let me see.
Is that, are we back on, you had 24 on your computer? It's concealment of materiality?
I know what that one is now, Your Honor.
Okay. The state's position? Y'all can read together, I mean, it's okay.
We can, yes, we enjoyed it.
Okay. What's the state's position?
The state's position is that the state's charge, as the court has agreed to give and with no defense objection, adequately covers this. So I think it's duplicative, but otherwise I don't have an objection.
Anything else, Mr. Petrie?
Your Honor, I believe that as long as the rule that it has to be a material fact is given to the jury, we don't really care about the form.
I understand. We'll not give 24 as written, but we'll cover it in, will not give 25.
Objection. I think that is not the state of the law in Georgia at this time. We'd ask the court not to give that.
Is this pattern right here? I know.
No, sir, it's not.
I know they asked you my question, but I just have to ask for the record. Is this pattern, Mr. Petrie?
No, sir.
All right. All right. Will not give, Mr. Petrie, noted. 26.
Your Honor, that's not the pattern charge. We'd ask that it not be given. It is not a statutory element.
I don't know that there is a pattern charge on this, Your Honor.
Yeah, we did not find one either.
I don't think there is, and this is a correct statement of law from a Georgia appellate case interpreting this statute in a manner that would assist the jury in determining whether or not there's guilt beyond a reasonable doubt.
The statutory elements of the offense are identified in the state's request to charge that's going to be given without defense objection, and that's not how the statutory elements
Right.
read.
And I understand, Mr. Petrie, will not give, yeah, I should say we, I should have said Ms. Jeffries did not find that either. I will not give 26 at this point in time. Exceptions noted. 27.
I object to that, Your Honor. That's not pattern. It's not even citing the Georgia case.
Mr. Petrie?
Your Honor, it goes even beyond Georgia. It goes to the United States Supreme Court and the Fifth Circuit from 77 when Georgia was still in the Fifth Circuit, so it's even more persuasive. And we would argue that the silence or non-disclosure is the lack of an affirmative act, and that the jury should be given this charge.
Let me put a question mark by that one, Ms. Jeffries. Let me think about it overnight. Number 28. Any objection?
I think the general intent language is already agreed to be given, Your Honor. There's no reason to identify this particular charge
Ms.
in
Petrie?
reference to intent, so we just ask that not be given.
Your Honor, it is our position that this is one of the offenses that does require a specific intent, and that therefore this should be given in addition to the general intent statute pattern charge, because they are, as we said, some of these crimes require a specific intent. This case, Owsley versus the state, establishes that, Your Honor, and I think it would be important for this jury to know that the general intent to do an act ain't going to cut it for that one charge.
I will give 28, Ms. Jeffries, in conjunction with, which charge were you referring to, Mr. Petrie?
Your Honor, that is on the concealment of a material fact.
Okay.
And I would have to look and see what the new numbers
But
are.
I will give. All right, 29.
I object to that, Your Honor. Don't need to say that. I think that as a comment on the evidence, I don't think there is again, beyond the requisite intent language and the...
Ms. Petrie?
Your Honor, and it says as to count 4, this was obviously drawn up at the time that what is now count 1 was count 4. And in this case, Your Honor, the statute requires that it be when the defendant knew or should have known, but the indictment alleges that she knew.
I understand.
So that is what we are asking that the court give, that she knew that Hemi Newman had committed a felony. And that's what it's alleged.
I understand.
It doesn't allege that she might have known or should have known.
Well, the jury will be charged on the language of the indictment, and the jury will be charged on the general intent language, and there's no reason other than a comment on the evidence that there would need to be a more specific reference to this individual.
Yeah, Mr. Petrie, I'm going to agree with Ms. Green on that one.
I'll just ask the court to
It's
keep
no-
an open mind until all the evidence is complete.
Oh, yeah, well, no, wait, this is tentative.
Yes, sir.
Open mind is provided.
Thank you, sir.
But as of right now, we're going to do it, we're going to do the final.
Preliminarily, I
Just
understand.
preliminary. Will not give 29, 30.
The state has the same objection to defense request 30.
Will not give as of right now, Mr. Petrie.
Preliminarily, thank you.
Preliminary. 31.
Same objection, Your Honor.
Will not give, Mr. Petrie, preliminarily. 32.
Same objection, Your Honor.
Will not give, Mr. Petrie, at this point in time. 33.
Objection, Your Honor, for the same reason.
Will not give at this time, Mr. Petrie. 34.
I think that's covered by the other items, Your Honor, but at the same time, that I don't have an objection to.
Well, if she doesn't have an objection, I'm going to not argue it, Your Honor.
All right. We'll give, Ms. Jeffries, we'll give 34, 35.
I believe that's covered by the charge that the state just admitted without objection.
All right. You said it's, so are you saying it's duplicit at this point?
I do think it is
All right.
the previous.
I concur if you're going to say that. Ms. Petrie? I'm going to give 34, but I will not give 35.
Yes, sir.
Ms. Jeffries will not give 35. 36.
I object to that, Your Honor. That's, again, the jurors will be charged on the indictment, they'll be charged on the general language of intent, and I don't believe that's applicable. I think that's a comment on the other.
Mr. Petrie?
I
anything
don't
else
think
for
that's a
Rick?
comment on that, but Sean, it's couched in terms of if and what was in the mind of the defendant at the time. It does not suggest what was in the speaker's mind.
Yes.
And I think this is a correct statement of law. It's been recognized as such by the Georgia Court of Appeals within the last 2 or 3 years. I believe it would be a rule of law that is not only accurate, but that could assist the jury in determining whether or not the state has met its burden.
Yes, sir. Will not give at this point in time. 37?
I think that is duplicative, Your Honor, of charges that we've already given without objection. I'd also note that there is I don't believe that's a correct statement.
Your Honor, this defense request number 37, Your Honor, we are inviting the court to create some new law for the state of Georgia on this. I think it is all good law. It's just not law that has been recognized as yet by the state of Georgia. There's nothing in it that is wrong. There's nothing in it that's bad. There's nothing in it that's incorrect. There's just no Georgia case directly on point.
I understand. And I consulted with Ms. Jeffries, and I appreciate that invitation. But I will not give and make new law this time.
Yes, sir.
I will not give at this point in time. 38?
38, I object to, Your Honor. I don't believe that is an accurate statement of the law. In fact, the case that we discussed yesterday, Dixon versus the state, came up during the defense directed verdict motion. I believe the General Demir as well indicated that it need not be strongly cooperative testimony to support the charge of perjury, need not be strongly cooperative of the testimony of other witnesses. I believe that is an inaccurate statement of the law. That's that not be given.
Mr. Petrie, anything else?
I believe that's a correct statement of the law, Your Honor, and it does offer guidance to the jury as to the level of corroboration required.
Will not give at this point in time. Number 38, 39.
I believe that's covered by charges already agreed to be given, Your Honor. I think it's duplicative.
I agree, Your Honor, that
39 is covered already. All right. Will not give 40.
I believe that's covered already, Your Honor.
Ms. Petrie?
Your Honor, the caveat that it says that must have been known by the defendant to be false, I believe that was covered in one of the state's requests, and it was intended by the defendant to mislead the fact finder. I believe that was given, and if so, then I agree with Ms. Cross that that is, in fact, a replica of what has already been agreed upon to be given.
It's covered, 40 is covered already. 41.
I believe that's already covered by a charge previously agreed
Ms.
to be
Petrie?
given.
Yes, Your Honor.
All right, it's covered. 41, 42.
I think that's already covered.
I agree, Your Honor.
Ms. Jeffries, 42 is covered. 43.
This charge, Your Honor, has been covered.
Ms. Petrie?
I don't think it has been covered, Your Honor. What this charge, request to charge, involves is what the speaker knew at the time the statement was made, as opposed to something that he or she learned later. And I don't.
Let me just read it out loud again. Not again, but I've read it, so let me read it out loud for you. The element of perjury that the false statement was made knowingly refers to knowledge at the time the statement was made under oath and not to subsequently acquired knowledge. I'm listening, Mr. Petrie.
Okay, Your Honor, for instance, I testified that an event happened on Tuesday, July the 15th. And I later discovered that Tuesday, July the 15th was non-existent, that it was in fact Tuesday, July the 16th. But at the time I made the statement, in good faith, I believe that it was Tuesday, July the 15th. It is not, the falsehood, the intent to mislead is not judged upon what knowledge was gained by the speaker later, but what was in the speaker's mind at the time the statement was made.
Ms. Green?
I think that proposition is adequately covered by the charges as previously agreed to be given.
And I disagree, Your Honor.
Yeah, I
I don't think
understand.
it was.
Ms. Petrie, 43, I will not give over objection, or will not give Ms. Jeffries over objection of the defense. 44.
For the same reason, Your Honor, we object to 44 as duplicative of charges already given.
Says here, the state must prove beyond a reasonable doubt that the defendant believed that the statement was false when made, period. If the fact was not true, comma, but the defendant believed it to be true at the time she testified, comma, she is not guilty of perjury. Yes, Mr. Petrie, anything else?
Yes, sir, that's cited by, that is supported by a case citation directly on point, Georgia law. It does explain a rule that I believe would help this jury determine when the defendant must have known or did know that a statement was in fact false. If in fact the jury finds that a statement was false, they need to take the next step. When did the defendant know?
I understand. Will not give over objection 45.
I think that's covered by the intent language, Your Honor, and the other charges already agreed to be given on perjury.
Ms. Petrie?
Your Honor, I would have the same argument that we have for 43 and 44.
A defendant's belief that her testimony was truthful constitutes an absolute defense to perjury, regardless of whether the testimony is actually false. Will not give. Exception is noted. 46.
I object to that, Your Honor. Again, I believe it's duplicative of language already given.
Mr. Petrie?
I do not believe it is. The nuances here, Your Honor, as to the extent of the falsehood and the knowledge of the falsehood are not touched on by any other request from the state or the defense, nor is it covered in the pattern charge. And this request is supported by...
I'll see the case. I'm going to read it. As to the charge of perjury, the evidence must prove beyond a reasonable doubt that the defendant's statement is false on every construction of the words used by the defendant, period. If words of the defendant's allegedly false statement can, by definition, be used to demonstrate either one fact or another, the defendant's statement would be false under one definition, but not under the other, then the state cannot prove beyond a reasonable doubt that the defendant's statement was false. Will not give. Exceptions noted. 47.
So objection, Your Honor. I believe that's covered adequately and more neutrally by other charges.
Mr. Petrie?
I agree, Your Honor. I'm not suggesting, though, that neutrality is what we're aiming for here.
I understand. Will not give. 47. Understood. 48.
I don't object to the proposition of the charge, but I believe that's adequately covered by previous charges.
We
It's
agree, Your
duplicative.
All right. Will not give. 48.
Same comment for defense request number 49, Your Honor. I think it's
Ms. Petrie?
It appears to be part of the previously agreed upon request.
All right. Will not give. It's covered already. Mr. Petrie, all I have, not all I have. We're at number 49. Any additional ones at this point in time?
No, sir, not at this time.
And Lloyd, this is what's called a preliminary charge for those who are visiting. You're more than welcome to supplement any additional request for charge at any time. And I'm more than welcome to get those. Matter of fact, you can email those to Ms. Jeffries at any time. She will check her email at the appropriate time, but you can send any additional requests for charge. Lloyd, this is a preliminary matter. Obviously, we can revisit whatever we need to revisit at the appropriate time. But we've spent a good amount of time. This is excellent use of time. The jury has been sitting home for the evening, and as we progress, we can revisit all of these issues. There's almost over 70 various requests for charge, which is wonderful. And when they can be supplemented, you can add them to this preliminary, and we can cover any additional information in those ones that we were holding on. We will go back over those, plus anything else we need to. Anything else for the record for right now, the state? Yes, Ms.
Oh,
Green.
Your Honor, just one more comment, if I could make it on defense request to charge number 27.
27, yes, ma'am.
Silence or non-disclosure is not affirmative act. I believe that there was, the facts of the case, there was an adoptive admission by the defendant that was admitted into evidence. There was a series of emails that were introduced by adoptive admission.
So what number was the defense? So what number
It was
was that?
defense number 27, Your Honor.
That's 20. Okay, I was looking at stuff. Thank you. Let me go back to that one. I put a question mark by it. I'm coming back to it.
Okay, I'm just
I mean,
noting.
what the question mark means, we're going to come in, that means I have a root on it.
Okay,
So it's not coming in, it's not going out.
thank you.
No, I understand. No. That's why, I'm not going to put a question mark, and Ms. Jeffries tagged it already. I'm going to put a green flag by it.
Thank you.
And
Thank
so
you.
we have several indicators. So no, question mark means it's not root on it.
Yes, sir.
No problem, not a problem. But wonderful. Thanks for bringing that to my attention. Mr. Petrie, anything else?
Nothing else for the record, Your Honor. I think we need to approach very briefly.
Oh, yeah, come on up, Lloyd.
Housekeeping
Yes.
for tomorrow.
No problem, no, come on up, Lloyd. Yes, come on up. All right, anything else for the record from the state, Mr. James?
No, sir, nothing from the state, Your Honor.
Mr. Petrie?
No, sir.
All right, Deputy Geary, we're in recess till 9 o'clock.
All rise.
Jeff Hellinger back with BJ